case on this morning's docket, and we're going to have to wait just a moment for Justice Beyer to take her seat because she is not recused on this case. In the meantime, let me call it. This is case number 114582 in the matter of Charles Vaughn. Counsel, you may proceed.
May I proceed, Mr. Chief Justice?
You may.
May it please the Court, Deputy Disciplinary Administrator Michael Serra appears on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, with the Court's permission, I would request 2 minutes for rebuttal.
2 minutes is granted.
Thank you. Members of the Court, this is an original action in attorney discipline. By way of background, this is a reciprocal action pursuant to Supreme Court Rule 202. The respondent in this case is licensed in the state of Florida, also the state of Montana and state of Colorado. The discipline in this case originated in the state of Florida, where the respondent was suspended for findings of attorney misconduct by the Florida Supreme Court in September of 2014. The respondent self-reported to the Disciplinary Administrator's Office on October 20th of that same year, and a hearing was convened on August 20th, 2015. Deputy Disciplinary Administrator Alexander Walzak had filed a complaint alleging violations of the Kansas Rules of Professional Conduct based on the findings of the Florida Supreme Court. The respondent answered and admitted to all allegations within the complaint. At the hearing, the respondent stipulated to the allegations as well as the facts and exhibits that were proposed by the Disciplinary Administrator's Office, and the hearing panel has recommended a 91-day suspension. That 91-day suspension is in keeping with what was ordered by the Florida Supreme Court, as well as the Montana Supreme Court and Colorado Supreme Court. The violations found and recommended by the hearing panel were Rule 1.2, Scope of Representation, Rule 1.3, Diligence, Rule 1.4, Communication, Rule 1.15, Safekeeping of Client Property, Rule 8.4c, engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, and Rule 8.4d, engaging in conduct prejudicial to the administration of justice. Given the recommendations of the hearing panel and the ABA standards in this case, I do believe a 91-day sanction is appropriate. The ABA standards, given the violations and the nature of the conduct in this case, certainly contemplate a suspension. 91 days does seem proportionate to the amount of harm caused to the client of the legal profession, but also taking into account any mitigating circumstances presented by the respondent. So that would be my recommendation to the court today, is that the respondent be suspended for 91 days. The hearing panel had made an additional recommendation that the respondent's license to practice law in Kansas not be reinstated until he is reinstated in the state of Florida. I have confirmed that the state of Florida Supreme Court referee, who is the person who handles the reinstatement hearings for the attorneys in that state, has recommended the respondent be reinstated. However, that has not been ruled on yet by their Supreme Court. So I would ask the court adopt the hearing panel recommendations and oppose a 91-day suspension in this case.
And that would be effective as of what date?
I would ask it be effective upon the order of the court.
Any further presentation?
Unless the court has additional questions for me, Your Honor, no.
I just have this curiosity about the 1. Is there something in the Florida system that 90 and less is a lesser graduated severity, or is there an explanation for that?
Justice Luker, I have reviewed the Florida Rules of Professional Conduct, which they have a similar framework to ours, but I did not see anything in there that specified 91 days as a finite rule for any specific violation. I could have missed something, I'll admit, but I didn't see anything in there. I think that was just the number the Florida court referee recommended and the court adopted.
Any more questions? Thank you, counsel.
May it please the court, Counsel, I will explain an answer to your Honor's question. My client has informed me that the difference is that under the Florida rules, if it is 91 days, then there is a necessity of reapplying for admission rather than simple reinstatement. I think, or a mechanical reinstatement. May it please the court. The respondent has detailed in his brief and in his statements to the hearing panel here through the documentation that is identical with Florida, and through that documentation that he does repent, he does have remorse for these actions, and that he has complied with the requirements of reinstatement made by the Florida referee as with the authority of the Florida Supreme Court. And the reason that I point that out to the court is that in this case, there is a detailed documentation of the fact that the respondent has, with, in my opinion, good faith and appropriately followed the recommendations or requirements for reinstatement. And so I ask the court solemnly to consider that fact. And I appreciate the court allowing me to file a brief on behalf of the respondent. I wish to inform the court that the desire to file the brief was communicated to me by my client, by the respondent himself. He specifically desired to do that. And I thank the court for extending that opportunity for that to be done. Now,
I have a question.
yes, ma'am.
On the recommendation, which trumps? So, for example, the suspension's already been served in essence in Florida.
Yes, ma'am.
But if it were effective upon issuance of this court's opinion, then it would not have yet have been served. So would that be an extra 91 days in Kansas, or would the provision of the panel's recommendation having the Kansas suspension run coterminous with the Florida trump?
Ma'am, my understanding is this.
Okay.
I've discussed this with my client, and I believe it's correct to say that if this court were to suspend effective today, then I believe that it would be correct to say that within the state of Kansas, for any Kansas matter, that the respondent would be suspended from practice for that time, and with whatever other requirements there would be. My understanding is that the Florida reinstatement, and the counsel for the petitioner has stated that he believes that will proceed. I believe, Your Honor, that the Florida mechanism and the Florida timeline and their actions will proceed. And I don't believe that this suspension would have any effect upon the occurrences of what are the expected timeline in Florida.
But
And
what
so
about
that
the
is that.
reverse? It's the reverse that I'm interested in. If the Kansas suspension is tied to the Florida suspension and the Florida suspension is lifted in 10 days, then does that affect? I'm
That's a
just
very
asking what's being asked.
Your Honor, that's a very good question.
Okay.
And the answer to that is this. I view it as the root of all of these procedures having arisen in Florida. And under the Florida procedure, there is, in my understanding, a practice and a custom, which does overlay anything in the law to some extent, of making a suspension concurrent, even if it may be retroactive. And so my understanding is that the practice is in Florida, in many cases, to observe that. Now, therefore, Your Honor, if that is the case, and then Florida actions and discipline are the root of all of these other proceedings, then that is why I believe that Florida will proceed on their own to reinstate the respondent in Florida, regardless of when this is done.
I understand that, counsel, but I think we're just not communicating. I'm not asking what Florida's gonna do,
Yes.
because Florida's gonna do what Florida's gonna do.
Yes,
And that's fine. They have their own jurisdiction
Yes.
and their own procedures and customs. I'm asking what the respondent desires from this court.
well, then.
If he's agreeable to the 91 days in Kansas, is he also agreeable that those 91 days will be served regardless of when Florida's suspension is lifted? That's my question.
Then, Your Honor, thank you.
Okay.
I just wanted to be as careful as I could be in answering. Sorry.
Sure, that's okay.
The respondent has told me that he would respectfully request the court to make the suspension to be coterminous with the Florida suspension. And I will offer some comment on that. In my understanding, Your Honor, the respondent did not and has not and is not, under any stretch of the imagination, there is no possibility that the respondent would be involved in any Kansas action, nor was he at the time of anything which originally took place. And the respondent, although he was educated here, and he's bless his heart, a very good friend of mine over many years, he had relocated himself entirely to the state of Florida. And at the time of these actions, Your Honor, nothing was in process. Does that help
Counsel,
answer?
could I ask a clarifying question, just to see if I have this accurately summarized? If we do as the disciplinary administrator asks us to do, and order today a 91-day suspension, it's your position that if 10 days from now Florida says he's now clear, that our suspension would then lift?
Oh, no, of
No?
course.
All right. So I have that wrong.
Yes, if Your Honor thought that I had said that, I certainly did not mean to say that. I was trying to be very careful to say that.
So in my example, if Florida lifts 10 days after our order of 91 days, our 91 days continues.
Yes, and
And similarly, if Florida takes a year from today to act on his proposal and then lifts, and then allows him back in the practice, that has no effect on our 91 days. It's 91 either way.
that is my understanding, Your Honor. Yes,
That's what you're asking on behalf of your client for us to do.
I'm asking on behalf of my client, Your Honor, for the court, and in my answer to the Justice's question, to make the suspension retroactive and coterminous with the Florida Act suspension, which in my understanding is to lift in 10 days from today, because as I gave in my explanation a moment ago, the practical effect of all of this is that the respondent had dissociated himself.
So just again to be clear, if this court were to adopt what I understood you just to recommend, and if we speedily got an order out today, and the Florida course continues as is expected, then your client would be suspended from the practice of law in Kansas for 10 days, essentially. That's what you're asking.
Well,
For the order to say that he's suspended retroactively, essentially, or simultaneously with the Florida action.
and Your Honor, I will say this. Yes, that is correct. The reason that I have suggested that is simply because there are no circumstances, there's no evidence, there's nothing to suggest that the respondent has not been globally, in effect, suspended as a result of all the proceedings that have already taken place in the state of Florida. But I absolutely respect and acknowledge that this court has its own independent authority to do whatever it should desire, and in this jurisdiction, whatever would take place in this jurisdiction would be solely within this court's power to regulate. I understand that.
And just another clarification, if Florida acts 10 days from today and says he's back in, then his suspension in Kansas would have been effectively for 10 days. You just acknowledged that to my colleague, Justice Stiegel, correct?
Yes, Your Honor, that's correct.
Similarly, if we do make a suspension coterminous with Florida, the same would hold true for the back end. If it takes Florida a year to finally get around to letting him back in on the practice of law, he would have been suspended in Kansas for that year.
Yes, Your Honor.
All right.
Yes. I want to make one more comment to the court, and I think that this is underlying the understanding of everyone in this room. The Florida Supreme Court certainly has its discretion, I'm sure, to do whatever it desires to do. And as Your Honor has rightly recognized, we don't know for sure what they will do, but we have a reasonable expectation of what they will do. And therefore, I would like to make this one additional comment along that line. If the Florida Supreme Court were to take as a signal some indication from this court of a 90-day suspension that would be effective now and continue for 90 days in this jurisdiction, then my thinking is that it could be that the Florida Supreme Court would be moved by that to change its mind and not reinstate him in 10 days and to continue for what would in effect be, I guess, 90 days or perhaps 100 days.
Did Colorado and Montana tie their suspensions to the Florida court's action? In other words, is he suspended in Colorado and Montana until reinstatement in Florida?
Your Honor, my understanding is that I believe the answer to that is no, that they did not. But I will leave that for
That's fine, thank you.
my client to explain. I don't want to cause any misunderstanding there. Your Honor, I went a little bit longer than I intended to do. I apologize. I wanted my client to have more time to address the court. If the court will allow that, I'd appreciate that. Thank you.
Counsel?
Thank you, Your Honor. Just as a point of clarification, the Montana Supreme Court had suspended me with that suspension ending April 28th. That suspension had started from the end of the Florida suspension by their discretion. During that period of time, what had happened was my attorney in Colorado had patterned the suspension for 91 days after Florida, but had made it to be the 91 days to be concurrent with my reinstatement in Florida. So that upon Florida reinstating me, then Colorado, I would be automatically, without having to reapply, I would be automatically reinstated in Colorado. So in Montana, I'm in good standing. In Colorado, I'm waiting on Florida. Now, my attorney in Florida had indicated to me that, and this was about a month ago, and I was told quite candidly by the Florida Bar Council back at the beginning of December that they had no objections to my reinstatement. And they signed a stipulation about 2 weeks after that was submitted to the referee, and the referee made his recommendation to the Supreme Court. And my attorney indicated to me that it would be about 30 days from that date before the reinstatement. And in checking the Supreme Court opinions in the state of Florida, it appears that the 28th would be about a month. So I'm anticipating Thursday to have that reinstatement from the Supreme Court. I don't see any impediment at this time. So I'm hoping that may clarify some of your questions. What I would be requesting, and my attorney has also indicated, is to have a concurrent suspension. This is an action that had started about 5 years ago, and believe me, it's been quite an ordeal. And sorry to have to put everybody through this, but I'm glad that it will be ended. But the suspension in Florida started on October 26th and ended January 25th, and what I'm requesting is this suspension be from October 26th to January 25th, 2015, and once my reinstatement in Florida is effective, to have that suspension be considered served at that time, if that makes things clear for the court.
You said January
25th, 2015.
15th.
If my math was correct.
So
it's
you're
October.
asking the court for a retroactive suspension,
Exactly.
which essentially means no effective suspension in the state of Kansas.
My position is, and I agree with the court, my position is I've served 2 91-day suspensions.
Right, I'm not
separately.
questioning the merits of it, just trying to clarify. That's what
Exactly.
you're asking for.
Exactly.
Okay.
Creative lawyering.
Any further presentation?
Other than in reference to my exhibits and my rehabilitation statement. Quite honestly, the last year and a half, having served an awful lot of volunteer times with Habitat for Humanity, hospice, the Guardian Ad Litem program in Florida, I've seen a lot. And perspective, and taking a year away from practicing law, my perspective has changed. And I believe my rehabilitation is sincere and it's been lengthy. And I appreciate the court's consideration. And that's all I have. Thank you.
Any more questions? Thank you, counsel. You're reserved 2 minutes for rebuttal.
Thank you, Your Honor.
Counsel, took us a while to understand exactly what the respondent desired, but I think we finally got a handle on it. Could you just give us the disciplinary administrator's response to that request?
The disciplinary administrator's response, Justice Beyer, is that the respondent be suspended for 90 days effective on order of the court. The hearing panel's recommendation was that the respondent should not be eligible to practice in the state until he has served 90 days and has been reinstated in the state of Florida. So, yes, Your Honor.
You're not asking for a reinstatement hearing, are you?
No, Your Honor.
Will there be a reinstatement fee?
Your Honor, this is an interesting question, and I've spoken with CLE about it. The respondent is inactive as of this date. So what I believe I am asking, and the hearing panel recommended, is that the respondent's inactive license be reinstated upon the 90 days being served and Florida reinstating him. There would be no fee beyond his annual registration fees for that to occur.
Well, I understand when we suspend someone and they request reinstatement, there's a, $1,200 fee or whatever. Is that only where we have required a hearing?
Your Honor, honestly, I don't know the
Okay.
answer to that question.
Well,
I apologize. That's not,
I should know, and I'll find
and
out.
honestly, so should I, but I apologize. I don't know the answer.
Thank you.
Any further presentation?
Beyond that, Your Honor, unless there are additional questions.
I see none. Thank you, counsel.
Thank you, Your Honor.
Thank you all for your arguments this morning. Court will take this matter under advisement.